Ghana Investment Promotion. Center ACT 2013. Act 865. Section 1. Application of the Act. 1. This Act applies to enterprises in Ghana. 2. Despite subsection 1, this Act shall not be interpreted to restrict compliance with the requirements of any other enactment. Skip Section 2. Section 3. Object of the Center. The object of the Center is to a. Create an enhanced, transparent and responsive environment for investment and the development of the Ghanaian economy through investment, and b. Encourage, promote and facilitate investment in the country. Section 4. Functions of the Center. The Center shall, for the purposes of attaining its object, actively encourage, promote and facilitate investment into and within Ghana, and shall a. Formulate investment promotion policies and plans, promotional incentives and marketing strategies to attract foreign and local investment in advanced technology, industries and skill-intensive services which enjoy good export market prospects. B. Initiate and support measures that will enhance the investment climate in Ghana for both Ghanaian and non-Ghanaian enterprises. C. Initiate, organize and participate in promotional activities such as exhibitions, conferences and seminars for the stimulation of investments, to present Ghana as an ideal investment destination. D. Collect, collate, analyze and disseminate information about investment opportunities and sources of investment capital, incentives available to investors, the investment climate, and advise upon request on the availability, choice or suitability of partners in joint venture projects. E. Register, monitor and keep records of all enterprises in Ghana. F. Register and keep record of all technology transfer agreements. G. Identify specific project and prepare project profiles on investment and joint venture opportunities in Ghana and attract interested investors for participation in those projects. H. Bring about harmonization in investment policy formulation through coordination of the activities of all other institutions and agencies, and I. Perform any other functions that are necessary for the attainment of the object of this Act. Skip sections 5 to 22. Section 23. Establishment of enterprises. A person who intends to establish an enterprise for the purposes of this Act shall incorporate or register the enterprise in accordance with the Companies Act, ACT 992, and other laws that are relevant to the establishment of the enterprise. Section 24. Registration of enterprises with the Center. 1. An enterprise in which foreign participation is permitted under this Act shall, after its incorporation or registration and before commencement of operations, be registered with the Center. 2. The Center shall, within 5 working days from the date of receipt of a completed registration form, register the enterprise if the Center is satisfied that a. All the relevant documents for registration are in order. B. The minimum foreign equity capital requirement has been complied with, and C. The fees required for registration has been paid. 3. An enterprise in which foreign participation is permitted under this Act shall renew its registration with the Center every 2 years. Section 25. Registration of wholly owned Ghanaian enterprises with the Center. An enterprise which is wholly owned by a Ghanaian A. May, after being incorporated or registered, be registered with the Center, and B. After being registered with the Center, shall be entitled to the benefits and incentives set out in this Act. Section 26. Benefits and incentives. 1. An enterprise registered by the Center is entitled to the benefits and incentives that are applicable to an enterprise of a similar nature under the Internal Revenue Act, 2000, Act 592. Value Added Tax Act, 1998, Act 546, and under Chapters 82, 84, 85, and 98 of the Customs. Harmonized Commodity and Tariff Code Schedule to the Customs, Excise, and Preventive Service Management Act, 1993, PNDCL 330, and any other relevant law. 2. An enterprise whose plant, machinery, equipment or parts of the plant, machinery or Equipment are not zero-rated under the Customs Harmonized Commodity and Tariff Code. Scheduled to the Customs, Excise and Preventive Service Management Act, 1993, PNDCL. 330, may submit an application for exemption from import duties and related charges on the plant, machinery or equipment or the part of the plant, machinery or equipment to the Center for onward submission to the Minister responsible for finance. 3. The Center shall before submitting a request for exemption to the Minister responsible for finance determine whether the request will facilitate changes in technology and promote the specialized use of machinery, equipment or other items necessary for the establishment and operation of the enterprise. 4. For the purpose of promoting identified strategic or major investments, the board may, in consultation with appropriate government agencies and with the approval of the President, A. Specify priority areas of investment and their applicable benefits and incentives, and B. Negotiate specific incentive packages for strategic investments in addition to the incentives available to any enterprise under the tax, customs, and other laws referred to in subsection 5. The board shall publish A. In the Gazette and on its website the criteria for determining what constitutes strategic investment and shall designate an investment that satisfies the criteria as strategic investment, and B. The details of special incentives awarded through negotiation under this section. Section 27. Activities reserved for Ghanaians and Ghanaian-owned enterprises. 1. A person who is not a citizen or an enterprise which is not wholly owned by citizens shall not invest or participate in A. The sale of goods or provision of services in a market, petty trading or hawking or selling of goods in a stall at any place. B. The operation of taxi or car hire service in an enterprise that has a fleet of less than 25 vehicles. C. The operation of a beauty salon or a barber shop. D. The printing of recharge scratch cards for the use of subscribers of telecommunication services. E. The production of exercise books and other basic stationery. F. The retail of finished pharmaceutical products. G. The production, supply and retail of sachet water, and H. All aspects of pool betting business and lotteries, except football pool. 2. The Minister in consultation with the board may by legislative instrument amend the list of enterprises reserved for citizens and enterprises wholly owned by citizens. Section 28. Enterprises eligible for foreign participation and minimum foreign capital requirement. 1. A person who is not a citizen may participate in an enterprise other than an enterprise specified in Section 27 if that person A. In the case of a joint enterprise with a partner who is a citizen, invest a foreign capital of not less than $200,000 United States dollars in cash or capital goods relevant to the investment or a combination of both by way of equity participation, and the partner who is a citizen does not have less than 10% equity participation in the joint enterprise, or B. Where the enterprise is wholly owned by that person, invest a foreign capital of not less than $500,000 United States dollars in cash or capital goods relevant to the investment or a combination of both by way of equity capital in the enterprise. 2. A person who is not a citizen may engage in a trading enterprise if that person invests in the enterprise not less than $1 million United States dollars in cash or goods and services relevant to the investments. 3. For the purpose of this section, trading includes the purchasing and selling of imported goods and services. 4. An enterprise referred to in subsection 2 shall employ at least 20 skilled Ghanaians. 5. The minimum foreign capital requirement of this section shall not apply to the foreign spouse of a citizen of Ghana to the extent that A. The foreign spouse is or has been married to a citizen of Ghana for a minimum period of 5 years continuously or holds an indefinite resident permit prior to registration of an enterprise. B. The marriage has been duly verified as having been validly conducted, and C. The foreign spouse is ordinarily resident in Ghana. 6. A citizen of Ghana who loses the citizenship by reason of the assumption of the citizenship of another country shall not be required to comply with the minimum capital requirement of this section. Section 29. Export trading and other enterprises exempted. 1. The minimum capital requirement specified in Section 28 does not apply to a. Portfolio investments. B. Enterprise set up solely for export trading and manufacturing. 2. For the purpose of this section, export trading includes export of goods or produce that originate from Ghana. Section 30. Prohibition against discrimination. Unless specifically provided for under an applicable legislation. A foreign investor, employer, or worker shall enjoy the same rights and be subject to the same duties and obligations applicable to citizens. B. The center, an official agency or any other legal representative of the center shall not discriminate against an investor from a particular country or give special treatment to a prospective foreign investor based on that investor's country of origin or nationality. C. A foreign investor is subject to the same laws that apply to domestic enterprises, particularly in relation to I. Licenses or other permits that are required of enterprises for conducting specific business activities. 2. Maintenance of business books and records in accordance with the recognized accounting standards. 3. Insurance requirements that apply to similar enterprises, and 4. Taxes required to be paid by enterprises which engage in similar activity. Section 31. Guarantee against expropriation. 1. Subject to the Constitution, any other relevant law and subsections 2 and 3. A. An enterprise shall not be nationalized or expropriated by government, and B. A person who owns, whether wholly or in part, the capital of an enterprise shall not be compelled by law to cede that person's capital to another person. 2. The Republic shall not acquire an enterprise to which this act applies unless the acquisition is in the national interest or for a public purpose and the acquisition is done under a law which makes provision for a. Payment of fair and adequate compensation, and b. A right of access to the High Court for the determination of the investor's interest or right, and the amount of compensation to which the investor is entitled. 3. Compensation payable under this section shall be paid without undue delay, and authorization shall be granted for the repatriation of the compensation in convertible currency, where applicable. Section 32. Investment guarantees, transfer of capital, profits and dividends, and personal remittances. Subject to the Foreign Exchange Act, 2006, Act 723, and the regulations and notices issued under the Foreign Exchange Act, an enterprise shall, through an authorized dealer bank, be guaranteed unconditional transferability in freely convertible currency of a. Dividends or net profits attributable to the investment made in the enterprise. b. Payments in respect of loan servicing where a foreign loan has been obtained. c. Fees and charges in respect of a technology transfer agreement registered under this Act. And d. The remittance of proceeds, net of all taxes and other obligations, in the event of sale or liquidation of the enterprise or any interest attributable to the investment in the enterprise. Section 33. Dispute resolution procedures. 1. Where a dispute arises between a foreign investor and the government in respect of an enterprise, effort shall be made through mutual discussion to reach an amicable settlement. 2. A dispute between a foreign investor and the government in respect of an enterprise to which this Act applies which is not amicably settled through mutual discussions within 6 months, may be submitted at the option of the aggrieved party to arbitration as follows. A. In accordance with the rules of procedure for arbitration of the United Nations Commission of International Trade Law, or b. In the case of a foreign investor, within the framework of any bilateral or multilateral agreement on investment protection to which the government and the country of which the investor is a national are parties, or c. In accordance with any other national or international machinery for the settlement of investment dispute agreed to by the parties. 3. Where in respect of a dispute, there is disagreement between the investor and the government as to the method of dispute settlement to be adopted, unless there is any arbitration agreement. To the contrary, the method of dispute settlement shall be mediation under the alternative Dispute Resolution Act, 2010, Act 798. Section 34. Labor and employment. 1. An enterprise registered under this Act shall abide by the applicable labor legislation. 2. Labor relations between an enterprise owned by an investor and the employees of the enterprise may be regulated by agreements made between the enterprise and the employees. But the agreement shall not establish standards lower than the mandatory requirements under the laws of Ghana. 3. Subject to this Act and any other applicable legislation, an investor may employ 8. Persons of any nationality to positions of management for the purpose of the conduct of investments and business activities, and b. No managerial staff of any nationality, but a citizen of similar qualification and experience shall have the first option. Section 35. Automatic expatriate quotas. 1. An enterprise which has a paid-up capital of a. Not less than I. 50,000 United States dollars and not more than 250,000 United States dollars is entitled to an automatic expatriate quota of 1 person. 2. 250,000 United States dollars and not more than 500,000 United States dollars is entitled to an automatic expatriate quota of 2 persons. 3. b. 500,000 United States dollars and not more than 700,000 United States dollars is entitled to an automatic expatriate quota of 3 persons, and more than 700,000 United States dollars is entitled to an automatic expatriate quota of 4 persons. 2. An enterprise that intends to employ an expatriate shall apply to the Center for Facilitation of the employment, and the application shall specify the number of expatriates to be employed, in accordance with the quota specified in subsection 1. 3. The application shall be decided on by the Center on the advice of the Ghana Immigration Service in consultation with the regulator of the relevant sector. 4. Despite subsection 1, the Ghana Immigration Service may refuse to grant a visa to an expatriate to whom a quota relates, if the Ghana Immigration Service has sufficient reason to believe that that expatriate is not a desirable person who should be permitted to enter the country. Section 36. Assistance to enterprises. The Center shall provide to an enterprise any assistance and guidance that the enterprise requires and act as a facilitator between the enterprise and relevant ministries, departments, agencies, and other public institutions. Section 37. Technology transfer agreements. 1. An enterprise may enter into a technology transfer agreement that the enterprise considers appropriate for the enterprise. 2. A technology transfer agreement entered into under subsection 1 shall be registered with the Center. 3. The Center shall maintain a record of technology transfer agreements. 4. The Center, on the receipt of a technology transfer agreement a. intended for registration, shall review the agreement, and b. shall, on registration of the agreement, monitor and ensure compliance with the terms and conditions of the agreement. 5. A technology transfer agreement registered under this Act comes into force on the date of the registration. 6. A technology transfer agreement may be renewed with the approval of the Center and the regulator of the relevant sector and is subject to registration by the Center. 7. A technology transfer agreement shall, in addition to this Act, be governed by regulations in force relating to that agreement. Skip Section 38. Section 39. Appeal against decisions of the Center. 1. A person dissatisfied with a decision of the Center may appeal to the board of the Center against the decision. 2. The appeal shall be made within 60 days after the appellant has been informed of the decision. 3. The board shall within 7 days after the receipt of the appeal set up a 3-member committee chaired by a member of the board to determine the appeal. 4. The committee shall, subject to the rules of natural justice and any procedures that may be prescribed by regulations, determine its own procedure. 5. The committee shall determine an appeal within 21 days after the submission of the appeal and may a. affirm the decision of the Center, b. vary the decision of the Center, or c. revoke the decision of the Center. 6. A person dissatisfied with the decision of the board may apply to the High Court for judicial review. Skip sections 40 and 41. Section 42. Regulations. 1. The Minister in consultation with the Board made by legislative instrument make regulations. 2. A. Prescribe for matters relating to technology transfer. B. Revise the list of enterprises reserved for citizens and enterprises wholly owned by Ghanaians. C. Prescribe procedures for the grant of licenses and privileges or exemptions. D. Prescribe the fees available in respect of registration, licensee privilege and exemptions. And E. Prescribe generally for the effective implementation of this Act. 2. The Board may make rules necessary for the efficient and effective implementation of this Act, and the rules may provide for A. The procedure by which applications may be submitted for registration, and B. The supervision, control and reporting of progress of an enterprise to which this Act applies. 3. The Chief Executive Officer shall A. Give public notice of the regulations, rules and of amendments of the regulations and rules, and B. Maintain at the offices of the Center a complete and updated set of the regulations and rules for inspection by an interested party. Ends here.